I'm often asked if a husband and wife must file bankruptcy together, and the answer is no. A husband and wife are able to file bankruptcy together if they wish as an administrative convenience, but they're not required to. Either spouse may file an individual bankruptcy without their spouse joining in. Now, the downside to that is that even though your spouse is not filing a joint bankruptcy case with you, you cannot escape the fact that you have household income and household expenses, both for purposes of Schedules I and J, where you're required to set forth the income monthly that you estimate or project that you will have, and the expenses that you will have each month, and also for means testing. For means testing purposes, you are also required to include the income from your spouse and household members. Now, you can work out of that equation some expenses that may be your spouse's only, such as a support obligation that they have to somebody else, or a car payment they have that's only in their name. But you can't escape the fact that your spouse's income are part of your household to try to come in below median, or try to lower the amount of disposable monthly income that means testing might produce. Now, debts and the type of property you have and how you hold it, those are factors that might influence your decision about whether it would be advantageous for you and your spouse to file together, or it would be better for only one spouse to file bankruptcy. We have a tenancy in Virginia known as a tenancy by the entirety with the common law right of survivorship. And one of the benefits of a husband and wife holding title to property in this particular tenancy is that it is protected from the claims or lien of the creditor or creditors of one spouse alone. Only a creditor with a joint debt can acquire a lien against a tenancy by the entirety. The IRS is the one exception to that. They also can acquire a lien if only one spouse is liable. But for the most part, only a joint creditor could attach that type of property. So if an individual files bankruptcy and has equity in the house that's held as tenants by the entirety, if there are no joint unsecured debts, the trustee may not have a right to sell that property to pay off the debts of that spouse. Now, if both spouses file bankruptcy, then the trustee may be able to sell property held as tenants by the entirety, where both parties are in the bankruptcy case as debtors. There are many other factors which might influence your decision about whether it's best to file individually or file jointly, such as the composition of your debt. Is the debt primarily one spouse's, or do both spouses have a considerable amount of joint debt? In some instances, even where there's some joint debt and you're not concerned about the tenancy by the entirety factor, it may be advantageous for only one spouse to file bankruptcy. You should discuss with your attorney whether you and your spouse should file bankruptcy together, or whether only an individual case might be best for you.